of the proposition to open the debate.
Sorry, just 1 minute here. All right. And PYs verbally, please. Within any given case, justice is gray, ambiguous, and murky. But opposition shoehorns justice and the criminal justice system into a stark black and white binary. This discrepancy has called assaulters to walk free on technicality in the world of opposition, and innocent Black teenagers to be ruled guilty on emotion and on prejudice. In the world of proposition, we acknowledge the time, investigation, and precision it takes to obtain justice. A swift binary cannot account for that. Imprecise justice is permanent injustice. Canada has 3 arguments to forward in this debate. First, on legal precision, second, on the innocent, and thirdly and finally, on plea deals and initiative speech. But before that, what is our stance? 2 parts. Number 1, this is a fact. Most legal systems make retrying a not guilty verdict very difficult or impossible entirely in the status quo. This is called double jeopardy, where you're tried for the same charge you were acquitted of, which emerged when there was less criticism of institutions and greater fear of government tyranny, meaning that any mistrial was assumed in their world to be perverse and unjust. What this means then is that double jeopardy and retrying a case after a not guilty verdict is near impossible in the world of opposition. Second, to retry a not proven case in our world, there's likely some high bar that a judge has to evaluate. For instance, via a preliminary hearing where prosecutors must show that new evidence has come about or some mistake was made in the original trial. What this means then is that this is very similar to current preliminary hearings that screen for sufficient evidence. Not every single trial is going to be retried. We think there are incentives on the parts of prosecutors to only retry cases with new evidence or evidence that would change the outcome of a trial. With that out of the way, first argument on legal precision. There are many cases in many trials in opposition's world where there's legitimate moral and legal ambiguity over whether or not someone is guilty, not guilty, or innocent. In these cases, which are separate parts of the argument, either A, the trial concludes that the person is not guilty when there's legal ambiguity over the availability of evidence about witness testimonies, the truth, and etc., or B, in a separate case, ambiguity leads to the jury deciding that someone is guilty on racial class biases, on these inherent biases, and a segment of emotion. I first want to talk about the former set of cases where a not guilty verdict is reached due to moral and legal ambiguity. Why do these cases happen? There's 2 structural reasons. Structural reason number 1 is that the criminal justice system often enters trials prematurely and quite quickly. This is true because A, the justice system is criminally overburdened and overstaffed. Judges and justices have too many cases on their docket. They want to get through these cases quickly so that an accused person isn't in jail forever and their lawyer doesn't get mad. B, public defenders are often juggling between dozens of cases on a daily basis, and not to mention they're quite underfunded and understaffed. But moreover, prosecutors, DAs, ADAs have electoral and timeframe incentives to tally as many verdicts as possible. They're often in competition for a re-election or appointment when it comes to prosecutors and district authorities. They often have a limited number of years that they can serve in their time frame and their electoral frame, which means they want to squeeze cases in. The last reason why trials are often rushed and overburdened on their side of the house is that the police often face mounting public pressure to get criminals off the streets because people genuinely care about their safety. They care about the community that they live in and the children that they grow up, which leads to police forces pursuing a promising piece of evidence in the world of opposition, even though it could lead to moral ambiguity in a case where you don't actually create a precise verdict. The second reason why trials are rushed on their side of the house, and I'm willing to take a POI after this, is that evidence is often unavailable, tampered with, or inadmissible. There's a range of situations where a not guilty verdict is reached, not because the person is genuinely innocent. In some sets of cases, the police might mislabel a piece of evidence, for instance, or fail to meet a court timeline to bring up a piece of evidence in discovery. In other cases, a key piece of evidence might be missing. There's not enough time for the police or the public to procure it, such as a dead body, for instance. But in other cases, the witnesses don't want to come forward, or it's the case that they might be a victim of witness intimidation, and they don't want to come forward in this particular time frame. The implication of all of the above framing is that there's a large margin and a large set of morally ambiguous cases where a not guilty verdict is reached out of convenience and moral ambiguity. We fix this. Why is this the case? First of all, police and prosecutors on our side of the house can learn from their mistakes. They can meet deadlines that haven't been met in the previous trial, and they can reframe their case since they now have time to look at strategy. Second of all, time allows for more evidence to be collected. There's a range of situations in which this is true. Witnesses might come forward after a not proven guilty when they otherwise wouldn't because they feel guilty that they could have actually provided evidence. A body might be found 3 years later by a hiker, for instance. There might be new methods of investigation. And given that this is a retrospective motion, they have to deal with DNA evidence being introduced a few decades ago at the turn of the century, which overturned a number of cases. NDAs might expire on their side of the house, which is an additional reason why time allows for more evidence to be collected. Part two of the argument then, but before I go on to part two, I'm willing to take a POI.
If new witnesses come forward or new evidence is discovered or brought before the jury, then we can simply request a retrial on the basis that new evidence has come to light. Why is a not proven verdict necessary in order to take this evidence into account?
So we already told you in point one that for a variety of reasons, the state is subjugating you. Retrials are often very rare or even impossible in some jurisdictions in your world. But I think there are other structural reasons that I'll touch on in part two of the argument. Part two of the argument. On the set of cases where a guilty verdict is reached. In many cases where there's lots of ambiguity over someone committed a crime, there is a default onto a guilty verdict. This is especially horrible since in these cases where jurors feel a pressure to reach a verdict, they want to go home, they want to go back to their job since juror compensation is low, they want to go back to their family and actually scroll on social media since they're often sequestered in isolated places. In these cases where pressure is high to reach a verdict, juries often resort to their gut instincts, their emotions, their perceptions, their inherent biases, and their racial biases. The fact that a 17-year-old Black youth on their side of the house is probably guilty because of a gut feeling and the fact that this juror wants to go home. We fix this on our side of the house because these are individuals who aren't fully convinced on this person's guilt. These are morally righteous individuals who have some racial tendencies and some racial biases, but out of convenience will cast a guilty ballot on their side of the house. These are individuals who are given a third option on our side of the house who do not need to resort to these emotional and racial biases. The weighing of this argument is simple. Number one, in principle, we should care about legal and moral precision. The criminal justice system is a violent arm of the state that holds a monopoly over violence over us. They can lock us into jail, they can take away our possessions and sequester us from our family and friends. It is the state's responsibility to determine guilt and non-guilt precisely because of the violation and because of the moral tyranny the state holds over us. Second of all, since this is a retrospective case, we have already proven in the above analysis that there's a lot of cases where moral ambiguity doesn't exist on our side of the house, where new evidence comes up, where you don't have to declare a mistrial, where you can do things like reframe the strategy of a prosecutorial case. This is why this argument is important. Second argument then on the innocent. Even in cases where people are genuinely innocent, these people are deemed guilty in the court of public opinion. This is true for a number of reasons. Number one, in the process of being convicted, the trial is often published, the mugshot of a criminal is out there, and people often internalize the fact that this person is someone who is guilty. This is often worse with the media sensationalization, where the media wants to portray this criminal as hardened and battle-hardened. Second of all, the average person understands that if someone is not proven guilty beyond a reasonable doubt, they often cast a non-guilty. There's a very high bar for guilt, which is why people, for safety reasons and self-protection reasons, err on the side of caution and assume that this individual is a guilty person. We fix this structurally because individuals who are certain over their guilt can be free from an employer who assumes guilt, can be free from a neighbor, for instance, who doesn't want a relationship with them, because these are individuals who are genuinely innocent, who are exonerated from the court of public opinion. In both sides of the house, innocent people face ambiguity, but on our side, many people are truly exonerated when there's this third option for morally ambiguous cases. This means that on our side of the house, these individuals who are genuinely innocent can get a job, can get a relationship, and that doesn't occur in the world of opposition. Imprecise justice is permanent injustice. We're very proud to propose.
Thank you for that speech. We welcome the first speaker of the opposition.
Hi, just checking I can be seen and heard clearly.
Yep.
Great. Just a reminder, they them pronouns, POI is in chat, please. Both sides of this debate agree that the criminal justice system in most countries is extremely burdened in terms of its monetary cost, in terms of human capital, in terms of physical space. I want to immediately clarify at the top of this debate in terms of threshold and their misunderstanding of the criminal justice system's incentives. Because in status quo, the threshold for criminal conviction is guilt beyond a reasonable doubt. This is because, as they say, we recognize the punishment is so secure and recognize the lifetime stigma that comes about with an individual getting a guilty verdict, which is why the justice system in status quo believes in innocent until proven guilty. On proposition, even though a person may not go to jail, they still lower the threshold for an individual to get a verdict that is anything except for a not guilty verdict by providing this third option. We think that what this third option does is maintain all the stigma of a guilty verdict without any of the ability to hold this or for this individual to get some sort of redress. That is the harm here. On counterfactual, I want to make it clear that calling for a mistrial exists on our side of the house. So if there has been a tainting of evidence, a problem with the jury, you can throw evidence out and reconsider evidence and redo the trial. This is because by the time you come to a verdict, you have to assume that all evidence has been considered. On proposition, even if there is no change to the evidence itself, they are still fine with retrying a case. On our side of the house, if new evidence is brought up, you can always bring that case up again with new witnesses. And this isn't just limited to prosecutors as they would have you claim. There are bunches of instances, in vast majority of instances, where this is done by defendants. Look at the Innocence Project, for example, that seeks to do this. 3 quick points of rebuttal before I move into argumentation. Firstly, on stance, I want to make it clear that this debate is not just retrospective. It is retrospective, but it's also about the future because it's a preferred motion. Secondly, their problem with double jeopardy isn't really a problem. We think that the presence of the double jeopardy principle is a good thing because it is that prevents abuse by the state. It is that prevents an individual who has been deemed not guilty from constantly being put back into trial where there is no new evidence brought up to create some sort of doubt. Second, responses as to their argument on the 2 instances of a trial. First, we consider resource limitation in the instance where they say in non-guilty verdicts there's trial rush, but you don't get rid of that overburdening of the system on their side of the house. We will prove through argumentation that it gets much, much worse. All their problems with missing evidence can be accounted for in a mistrial, but we think that they concede ambiguity here. We will thus prove in argumentation that it is better when ambiguous for an individual to get a not guilty verdict than it is for them to get a not proven verdict. Second, in terms of the second group of instances where people are considered guilty by default, second, the response here is that this simply isn't untrue. This goes against the incentives of the justice system, which is to ensure that people have a very high bar for being considered guilty. But if we are able to prove that biases get worse on proposition, we're able to get rid of all of the analysis. The second argument very clearly clashes with my second, so I'll deal with it there and do the weighing there. Before my argumentation goes.
When a non-guilty verdict is reached, the police close cases and stop searching for evidence to maximize resources, which is important because the police has access to superior technology and crime scenes. Why are cases on your side of the house likely to be reopened because of a discovery of evidence?
Because evidence is always going to be found later down the line. You yourself conceded that when new technology like DNA finding came about, that we were able to find new evidence. That in and of itself is a concession that you're always able to get new evidence. I'd also want to point out that police don't have an incentive to just close cases as soon as the trial is done. They also have an incentive to bring up those cases because it's good for their reputation. First argument as to why this leads to less fair trials on their side of the house. I want to make it clear that jurors have preconceived notions of defendants even if you lack sufficient evidence. This is because of subconscious bias regarding an individual's race or religion, media bias that wants to do things like fearmonger, the fact that people overestimate their own abilities to intuit a person's guilt. On our side of the house, juries cannot act upon these biases for 3 reasons. 1, they have to rationalize their decision when they present it to the court in terms of coming to a conclusion. Second, jury selection is done by lawyers in order to ensure that there is a prevention of bias within jurors. 3, there are checking mechanisms to ensure that any form of egregious bias within a court is taken out. For example, you're able to get rid of a juror if they exhibit some sort of bias, which means there is no ability to deem an individual guilty on our side of the house if they lack evidence, and it is more than likely that they are going to be considered not guilty. On their side of the house, what they do is introduce a third option. What does this mean? In an instance where there is a lack of evidence, you allow juries to use their own intuition to justify gaps and bump up an individual's verdict from not guilty to not proven. And they're able to do this because they're able to rationalize this by saying, we don't have the evidence, but it is likely that this person is guilty. I feel that this person is guilty. Therefore, we're going to bump them up from not guilty to not proven. Prosecutors also have an incentive to do this on their side of the house because bumping up the verdict from not guilty to not proven betters their own reputation. So they are more likely to appeal to these biases, such as racial biases and ethnic biases. The conclusion of this argument is that more people are likely to be racially profiled and receive a not proven verdict where they would otherwise get a not guilty verdict. This is bad because in most cases, if you lack evidence, it more than likely means the person is innocent. If witnesses are unsure if it was the same person, if you cannot find evidence like bloody footprints, it is more than likely considered that that person is innocent. This is an instance where there is a state failure. The state has a duty to collect all the evidence it can and prosecute this person. It is unjustified to punish the accused on the basis that the state is unable to do its job. But we think this hurts the underprivileged the most because there is likely to be a double standard. A white person with a not proven verdict is likely to be seen as innocent, whereas a black person with a not proven verdict is more likely to be seen as guilty, preventing them from doing things like accessing job opportunities. On our side of the house, when you have a not guilty verdict for both a black and white person, it is much harder for those racial biases to seep out in employment. But the second thing is just force more minorities into jail. If you can constantly retry this, think about what this means for poor people who can't afford legal representation over the long term. What this means is that you're more likely to force them into things like plea deals because they have to go through more and more trials, and over time they won't be able to afford it, putting more black people in jail and fueling the prison industrial complex. The conclusion of this argument is that this policy just enables racism and leads to a less fair justice system. Second argument as to why this worsens the incentives of prosecutors. They concede that in almost every country, district attorneys in charge of prosecution are elected, which means that at the end of an electoral cycle, they want to get re-elected. What this does on their side of the house is create an incentive to retry only the not proven cases of those that will yield the greatest public attention. A Tamil man in Sri Lanka, for example, is much more likely to be tried by a district attorney than a Sinhala man is. What this does is allow the state to constantly hold the not proven verdict over someone's head. This has the same harms as double jeopardy because of the coercive effect of this threat in terms of the mental health that this person knows that there's always a chance that they could be pulled back into court, the inconvenience of constantly having to go back to court, the bias that you create in terms of their community all exist. What is the conclusion of this argument? You create an incentive to put more people under the threat of a retrial and thus create greater harms to people who are accused of crimes more likely than not racial minorities. I want to make it clear that giving a person a not proven verdict is not an absolvance of their crime or an absolvance of their guilt in the court of public opinion. More likely than not, this is more likely to ensure that an individual who lacks the evidence is going to be put in a situation where the public sees them as worse than they actually are. On our side of the house, you have a stamp on your name that says that you are not guilty, which means that the bias that you talk about is likely to be less so because you are less able to override that than you are able to put your own personal biases on the idea of not proven. It is for this reason that their system is just fundamentally a racist one and we should oppose it.
Thank you for that speech. We welcome the second speaker of the proposition.
Hello, can you hear me?
Yep.
There are arguments. Sorry. Sorry, I'm just missing one big round. Okay, and I prefer verbal POIs, if that's possible. I want to do three things in this speech. The first thing I want to do is clear up the stance around when mistrials and retrials can happen in either world. Second of all, I'll talk to you about the constructive issues in terms of how justice is applied and whether that's precise. And then third of all, I'll talk to you about plea deals. On the first issue, Sri Lanka's core response to much of our case is that if new trial and things like that exist, they can always bring up a new trial in their world, and thus they try to mitigate out our harms in terms of new evidence emerging. The first thing to know is that this is vaguely tense with other things they say in their own case. So they themselves concede that double jeopardy is a standard that exists in most Western or most liberal court systems, and they say it's good, which presumably suggests that there's a significant margin of cases in which there is some barrier in order to be able to retry that case. I also just don't think they deal with a lot of the reasons that we gave you from first in terms of why this legal standard is very common. The fact that most of these legal systems evolved during periods of time where the government was perceived to be corrupt or illegitimate, where there wasn't sufficient public will in order to have a higher standards of justice. And that meant that most legal systems disproportionately favored the defendants getting off not guilty in a way that suggests that retrials are difficult. This also applies in terms of things like the resource incentives of prosecutors or of legal systems to not retry these cases. I think that is less strong in a world where there is a norm of these retrials being an option in every single case. The other and the last thing to note is that even in a situation where they can still have retrials, it's far less likely that this evidence emerges to begin with. We suggested in first that the fact that there is a not proven guilty verdict means that you have some ambiguity, which means that police and other forces are likely to continue looking into new evidence emerging. They suggest there are reputational incentives to continue looking for this evidence. But the point is that under their own framing, you are conclusively convinced that this person is definitely innocent. So there's no reason why you continue to look in those areas, given that there is a direct trade-off between the police's resources that could be spent in other areas, for example, and even people within local communities under their characterization, which is that you are deeply convinced that an innocent person is in fact innocent, means that you're unlikely to keep thinking about that case. It's unlikely to be prominent in the media, and as a result, less evidence emerges in their world. The last thing to say is that there's a clear margin in terms of how retrials apply in either world. So appeals are not a sufficient mechanism for them to use here because it requires the defendant to push against a legal system, which often requires things like resources and money in order to launch an appeal. Whereas in our world, it is something that prosecutors can engage in automatically. So there is a margin there. The last thing that they say in terms of stance is that there are going to be lots of retrials and financially disprivileged people won't be able to afford it. I think our stance dealt with this in terms of why the judge is going to mediate which cases of retrials go through. This is similar to existing mechanisms where judges have to go into trial first. There probably is a standard. There has to be things like new evidence or new norms that mean that a trial is necessary. But lastly, I'll just note that lots of our case exists regardless and needed more response in terms of why it is that biased juries and ambiguous cases over prosecute people. So talking then about their first claim in Sri Lanka's case, they say before, where the verdict would have been innocent, now it will be not proven due to some underlying incentives in juries to be indecisive. And as a product of that, these people will face more social stigma. The first thing to note is that I think that there's a bit of, this argument lacks a bit of coherency in terms of what the psychological issues with juries are, because we give you contrasting material in terms of why juries are often risk averse to things like violent crime occurring in their own communities, which means you are more biased towards promoting a guilty verdict in those cases. But second of all, this argument is clearly hinged on them proving that there is a significant margin in terms of the social stigma that exists between a not proven and an innocent verdict. The core thing to note here is that a not proven verdict in a case where, in terms of its social perception, is not really that different in terms of the way that not guilty verdicts are perceived right now, which is to say, in the current world, given the level of ambiguity that both teams agree that exists in this world, a not guilty verdict is just not that meaningful because people know that there is such a high standard of reasonable doubt in trials that someone who receives a not guilty verdict could in fact actually be guilty. The fact that the media has already reported on these cases taking place, even if the person doesn't eventually get prosecuted, the fact that people within those communities see the trial going on and know that a person, even regardless of the eventual verdict, being not guilty, is that there is some ambiguity on that crime existing. The key thing to note is that people are risk averse in most cases. Even in a situation where the justice system has said that someone is not guilty, they would rather, in a case of employment, hire someone who has never been through that trial process to begin with. And it is usually quite easy to find that information, either in a retrospective sense, where communities were small and you knew about all the trials going on around you, or in a modern sense, where there is more access to information for things like social media and the internet in a way which means you know that people went through those trials. So the margin in terms of social stigma is very small here because the current result of not guilty is not meaningful in the minds of most employers and stuff like that. We bring you two contrasting pieces of content, which I'll deal with after the POI.
What is comparatively worse for your reputation? A non-guilty stamp on your record, or the idea that you were definitely guilty, but there just wasn't enough evidence to convict you?
So I just don't think this is comparative to our second argument. What we suggested is that there is some pool of people who are going to get a not guilty or an unproven verdict. In your world, everyone within that pool is branded with the same social stigma of ambiguity existing under a not guilty verdict. In our world, the people who are not proven are subject to some social stigma, which is similar to that. That we can see. But what is distinct is that there is a pool of people who receive a not guilty verdict in our world, which is actually made meaningful by the fact that you've been conclusively proved innocent, rather than just the jury kind of not knowing what was happening and you could have actually been guilty in that case. Talking about our constructive case then, we said, first of all, there are guilty people who do not face justice in their world due to the emergence of new evidence. And second of all, even absent their stuff on retrials, the fact that social norms evolve. So for instance, a few decades ago, it might have been the case that sexual assaulters were considerably under prosecuted by the justice system because of jury's biases. But in a world where you can push that as a reason for retrial after a not proven verdict, it's far more likely that a more progressive jury is likely to favor that. This also applies in situations where political or organized crime contexts evolve over time. So in the immediate aftermath of crime or conflict, people are probably unwilling to testify because there are things like a direct threat of retaliation. But when these situations evolve and that group loses dominance, it means that more people are likely to testify under the retrial, which means you're able to hold people to account in the long run. Secondly, and this was the part that was least contingent on the model quibble, that in cases of marginalized people, prejudiced people tend to defer towards guilty verdicts because they're risk averse and don't want people they perceive as dangerous to exist in the community. All opposition says here is that there are checks on biases, but these were insufficient because it is difficult to find out what is inside people's psyche. And the core characterization was that jurors, for example, were not actively racist or malicious, but they were willing to consider rationality initially. But our biased instincts are often strongest in cases where we don't know what to do and are pressured by the clock. This is why the highest degree of job discrimination happens between candidates that are competitive, or why the police tends to commit more brutality in fast-paced, intense moments compared to relaxed ones where things are more clear. Because it is stress and indecision that activates our underlying racial biases, cases where we don't know what to do. That even on a psychological level, you are less likely to process things rationally in a situation where you feel rushed. And that means that in all of these cases, there is pre-existing bias that map onto this, where in our world, they could have just said what they thought, which is the trial was ambiguous, and been satisfied with that decision. The weighing here is important. We think precise justice internal to the legal system is far more important than social effects for two reasons. Firstly, the state has unique moral obligations towards citizens to distribute punishment fairly. The state has immense power over people through the police, through courts, and through a complex network of prisons and cages. And subjecting people to these structures unjustly is worse than whatever exogenous social factors happen in society, because the same power differential does not exist. Second of all, state punishment is more concrete and permanent than social stigma. If you are unemployed on the small margins of social stigma that opposition accesses, you can do things like go to different jurisdictions where you're less clear, or participate in social programs. Whereas if you are psychologically damaged by a prison, that is irreversible. Imprecise justice is permanent injustice. We are very proud to oppose.
All right, just give me one moment. Okay, thank you for that speech. We welcome the second speaker of the opposition.
Hi, can everyone hear me? Thanks. I'll take POIs in chat, by the way. I think it's important in this debate to identify the two groups that the two sides are trying to talk about because they're quite distinct. Proposition seems to be talking about guilty people that otherwise would have received an innocent verdict and who you would not be able to retry, receiving a not proven verdict, which extends that trial in such a way that you're able to gather new evidence and retry them at a later date. The kinds of people that we are talking about are people that are innocent of the crimes that they have been convicted of. But because there is inconclusive evidence where they otherwise would have received an innocent verdict on the basis of inconclusive evidence, you allow juries to step in and rationalize making a decision despite the lack of evidence on the basis that they are merely giving this person a not proven trial and not convicting them of the crime, and therefore they can rely on their own intuition to do so. The weighing between these two groups is clear. Even if both sides' benefits are likely, generally, if people are guilty of the crimes that they have committed, there is almost always conclusive evidence to prove that for two reasons. Firstly, massive improvements in technology have meant that we have access to more material evidence than ever. DNA that people inevitably leave behind at the crime scene. Eyewitness reporting, which has become more accurate over time as we have gotten psychologists to be able to vet people. Evidence through things like CCTV and closed circuit cameras that is more accessible, particularly in urban cities where people are constantly being monitored inadvertently as a result of this. But fourthly, the incentives of law enforcement. Generally, they want to put people behind bars and prevent criminals from re-entering society, which means that in the short time that is available to them, there's a massive incentive to gather as much evidence as possible. Hence why the police force does things like go out and talk to witnesses or contacts the media to be able to do things like distribute flyers with the person's name and face on it. I would add to this, given that trials are retrospective, all evidence is technically available. It's just that it has to be discovered at some point in time. And finally, I would add that in the worst case, where new evidence comes to light, retrials are possible, but I'll justify that later as well. The conclusion of this argument is that if people are guilty, there's often sufficient evidence, which means that they would receive a guilty verdict on our side of the house. Hence, the reason for why proposition wants this not proven verdict, which is to extend the trial, only applies in a minority of cases. Comparatively, there are many instances where people who are innocent of crimes are convicted of a crime that they did not commit. There might be some evidence, such as eyewitness testimony, which is incredibly unreliable. But there is also other evidence which goes and contradicts the fact that this person was at the scene of the crime or that they committed the crime. Note that this is the vast majority of crimes, given their own incentives about how law enforcement wants to do things like over-police particular communities. For these people, they are left the most vulnerable when a not proven verdict is allowed because of the analysis that we made in our first speech, which is that you empower juries to disregard evidence and rely on their own intuition. So on weighing, we've already won this clash. This makes me into direct responses. The first thing that I want to respond to in this speech is what the conditions are for retrials to be made possible on our side of the house. Firstly, I want to point out in their first speech, they concede that when new evidence is brought to light, you are obligated as the state to conduct a retrial because at the point in time where you came to the prior conviction, you were not making that decision on the basis of all the evidence that was available. Clearly, this is not the kind of vague, ambiguous spectrum that proposition wants to talk about. There's a clear binary between having a piece of evidence and not having that piece of evidence, as is true with DNA evidence that in many instances exonerates people of crimes that they were convicted of. So clearly there is an ability to identify when new evidence needs to be brought to light. But aside from that, there are three structural reasons why in many instances, retrials will be made possible if new evidence is brought to light. Firstly, if it is true that there are guilty people who have received innocent verdicts and are walking away scot-free, the justice system and the state has an incentive to guarantee that a retrial occurs because these people are more likely to reoffend in the future, given that they have managed to get away with it once before and they're likely to be part of things like organized crime. So clearly in instances where there's insufficient evidence and people receive an innocent verdict, there's an incentive to retrial. In instances where people are innocent of the crime, but they are convicted guilty, your defendants can in many instances appeal for a retrial, such as through things like the Innocence Project, which I would point out comes at no monetary cost to the people who are involved in those trials, given that it is a volunteer organization. So clearly there are opportunities for people to appeal. In many instances, even the most amateur lawyers have the ability to do this. The third thing that I want to point out is that if new evidence exists, there's massive public scrutiny on the state to guarantee that people are given a fair trial, given that without doing this, the state puts itself at massive legal liability liability for unjust imprisonment on the basis that new evidence has come to light, but that the state is failing to regard this evidence and give people a retrial, therefore unjustly holding them under convictions that have been made redundant. So there's legal exposure that the state wants to limit, hence why they will allow retrials. This massively outframes a lot of propositions case, because their claim about legal ambiguity is entirely symmetric in a world in which retrials are possible. But I want to respond to it anyway. They say that because there's legal ambiguity on their side of the house, it is necessary that retrials are always made an option. I have two responses to this argument. The first is that there is still an ability to account for this legal ambiguity, even when the possibility of retrials is not made available, because the state is still able to control things like what particular point at time at which it chooses to launch a case against an organized crime syndicate, for example. So you often, over years and a long period of time, accumulate enough sufficient evidence to be able to do things like prosecute organized crime bosses, because you know that it is necessary that once you get into a trial, you receive a guilty verdict for that particular charge. So I think the incentive to prematurely pursue trials is already limited. Comparatively, on their side of the house, law enforcement is far more likely to launch premature trials because they know that they have an inexhaustible ability to continue to try people on the basis that they can simply push the jury to give a not proven verdict. So trials become less efficient on their side of the house. I want to directly compare their material then to our material, given that I've already outframed it and proved by ours is the majority burden. We told you that in a world in which many innocent people are often convicted of crimes where there is some evidence that they might have died, but a majority of evidence that suggests it isn't, juries must rely on the available evidence in order to come to conclusions, because the counterfactual is one in which they rely on things like subconscious biases and their intuitions. What are these subconscious biases? Firstly, racial and gender profiling. You believe that men are more violent or that minorities are more violent because the media also chooses to sensationalize and fearmonger through things like the overreporting of crime statistics. But thirdly, many jurors, in a world in which a not proven verdict is made available to them, are likely to defer to their own authority as armchair psychologists because they think that the court has given them the ability to disregard the fact that there is insufficient evidence and rely on their own intuition in order to come to particular decisions. So you are far more likely to see a world in which people do things like rely on the reactions that people have in court as a way to justify their particular decision. They say that people are risk averse, but it is precisely for that reason that you will rely more on your intuition to give a not proven verdict where you otherwise think a minority criminal who otherwise would have gone completely free on an innocent verdict is now at least vested with the stigma of receiving a guilty verdict. Comparatively, on our side of the house, people have far less discretion. Judges have to justify their decisions in a world in which they make the convictions, and there's the ability to guarantee that jurors who disregard evidence are cause for retrial on our side of the house as well. Finally, on their side of the house, they worsen the incentives of prosecutors because they're more likely to shorten trials. Prosecutors can rationalize a large volume of not proven verdicts as a net win, given that clearing the docket is the priority in a world in which the criminal justice system is overburdened. This is uniquely harmful because you get shorter trials on their side of the house where the prosecution itself doesn't have an incentive to explore the full extent of the evidence because they know at a later point in time, if the DA so chooses to do so, you can always retry these cases. Victims of crimes are uniquely vulnerable in instances of criminal trials because they rely on the state to effectively prosecute criminals. In a world in which you create worse incentives for prosecutors to shorten trials and pursue not proven verdicts, you are less likely to get justice for victims. For all these reasons, oppose.
Thank you for that speech. We welcome the third speaker of the problem.
Hello, am I audible? Great. I'll take verbal POIs. Starting in 3, 2, 1. Opposition hinges their entire positive benefit in this debate on a simple link that they never prove. And that link is why, in the status quo, a not guilty verdict, where you are assumed to be grouped in as an innocent person with anybody who has ever been let go due to a procedural failure, due to an error in technology, or to a bad prosecutorial strategy, why that status is so much better than being labeled as not proven. That's all their positive benefits. If we deal with that link, we win this round. Two themes then in this round. Firstly, on the precision of legal methods, and secondly, on social stigma. So On social stigma or on legal precision, I think there's a quibble on the model here where we say double jeopardy means retrials are unlikely or impossible in many contexts. Now they say, well, you can get retrials on ours. So I want to note that when it's convenient for them, they admit that there are pretty big barriers to retrials in the status quo, right? At the end of the last opposition speech, they say prosecutors won't try in trials because they know they can retry these trials at any time, which seems to concede that there's a difference on both sides of the house as to how easy it is to get a retrial. And we think this is a really important concession that they make, because in order for retrials to be possible and that they have to be effective, you need the people who make trials possible to consider retrials as a likely opportunity. What does that mean? Well, as we tell you right out of first and down bench, you need people to retain evidence in police evidence lockers and maintain it. You need people to continue investigations, maintain records of witness testimony, retain records of like original investigations. You need people who are on the force with this knowledge, and if they retire, passing that knowledge on in the case of a retrial. And so we think in many cases, even if it's technically possible on their side to get a retrial, if you try to do a retrial a few years down the line, you're just not going to have the basis to do it anymore because they're so rare and so uncommon. But the second thing to note under this model issue is massive parts of our case, unlike what they say, are not in any way dependent on us winning this point, right? We say, maybe you get retrials for new evidence, and that does make some of our case symmetric. But what is not symmetric? One, you can't have a retrial because new technology developed, right? And we think this is a pretty big margin, right? On their side, they have to defend not reopening trials with access to new DNA analysis, with access to fiber analysis of different ropes and fragments. Secondly, we say you can't open a retrial because your prosecutor used a bad strategy or because they hired a very expensive lawyer that intimidated whoever the public prosecutor was. And so we think there is some margin here on precision of proving verdicts. So we think we do succeed in establishing a benefit on getting people who are guilty sent into the jail they need and making people feel safe. What else do we say on this argument? We say there is also a case where in the status quo, due to the ambiguity of the trial system, people are sentencing others guilty in situations where they would rather do it non-proven. And note that this directly engages with a big part of their case about when they say that racist people are going to move people from not guilty to not proven on our side. We say, because juries in many cases are racist or exist in racist communities, because they might be morally disgusted with a defendant, even if they don't believe they committed the crime, because they just want to go home and make a clear verdict, or because they're in a jury room and being peer pressured by the loudest voice in the room, there are many instances where, in cases of ambiguity, they might rule on the side of guilty. But on our side, the burden or the barrier to do this is much, much higher, because when you have the option of representing your ambiguity with a not proven verdict, you're much harder to pressure. Why is that? Well, A, if you're being pressured by your community to bring in an offender, maybe they're racist and the defendant is Black, maybe they are really concerned about the crime and they want to see somebody get punished for it. If you have a not proven verdict, you have a shield, right? You say, the government gave me this option to say, if the case wasn't made well, it wasn't made well, I had to do this, there's ambiguity. But you cannot defend an innocent verdict in the same way. The second thing to note here is that even internally on the inside, when people feel a great deal of doubt, their biases might allow them to act out in a binary situation if they have to choose between total innocence and total guilt. But if they are confused and we give them an opposite to represent confusion, we think it's pretty simple that in many cases, they're simply going to choose to represent that confusion. And that's a really big impact in this round, right? Because there are many, many cases that crimes, despite what they'll have you believe, are ambiguous. And in these cases, we ensure that people who should not go to jail, who should not face 20-year life sentences or something, do not go to jail on our side. And I want to engage with their weighing here. So they say, we are talking about a group that is given like retrials, not proven cases, and they're talking about a group of innocent people who move to not proven. So I want to engage with this big point now as I move into a theme about social stigma. They say, the reason that they should win on this theme is that guilt is conclusive in most cases. So the first thing is this contradicts all of their material on how innocent people are found guilty on either side of the house, if this is true. The second thing to note is their mechs under this point are quite bad. They say, firstly, technology allows us to establish crime in all cases, right? This is obviously not true in a retrospective motion, and it's not true in the status quo. There are not cameras in every street corner. The thing they say is law enforcement want convictions. Yes, but as characterized right out of first, law enforcement is overburdened. They don't have the time to sentence every case. They're going to have to rush some cases, misfile paperwork, and they're not going to get all those convictions. But there's also a general response here, which is just that if you think about the crimes that are committed, right? Murders in a secluded forest, robberies that occur where a witness doesn't see anything, right? Carjackings. These things don't necessarily occur around technology. There's no like reason they give why there's evidence left behind in every single case. And we think just the inherent nature of how crime can occur at any time, anywhere, by anybody is a likely mechanism for why there's ambiguity. Before I move on, I'll take a PY.
Our claim was that in most instances where people are actually guilty, there is likely to be sufficient evidence. On the other hand, there are many instances where there is some evidence to prove that somebody might possibly be guilty of a crime, but there is countervailing evidence in instances where you give juries the discretion to.
So I'll respond to this. So I think I just responded to why there's always evidence if somebody's guilty of a crime, and I said why that's not true. The second thing to note here is a point on weighing, and I think this is a central theme in this debate, right? They have rested a lot of their positive benefits on expecting you to believe that moving someone from a not guilty verdict to a not proven verdict, maybe in the case of minorities, maybe just generally, is a really bad thing. And we just don't think that's true. We frame to you in second and first, and this isn't adequately engaged with. We say, in the status quo, a not guilty verdict is seen as ambiguous because people watch shows where people get off for procedural mistrials because they see high-profile cases of politicians walking for corruption, and they know that a not guilty verdict does not necessarily reflect that somebody is not guilty. What do we say to you on our side? We give you a positive argument. We say, at least on our side of the house, yes, there's going to be some group of people who is still exposed to the harms of an ambiguous sentence, but there is also a large group of people who can conclusively be proved to not have committed the crimes they were accused of, who are totally emancipated from social stigma. And this is important because their argument has no tipping point, right? Why is the slightest degree more ambiguity? Why is the slightest suspicion more that you're guilty with a not proven verdict? Why does that change anything in your life? Are employers really less likely to hire you based on this tiny margin? Are people really less likely not to talk to you based on this tiny margin? No, but on our side, when we get rid of all that ambiguity for a specific group of people, these people are able to fully re-engage in normal life. They're able to experience the benefits of innocence as if they had never committed that crime. So we think we outweigh them here on a social stigma point because we actually produce effects for the most vulnerable actors who are in many cases victims of police bias who have now been conclusively proven to be innocent. And now I just want to provide a big piece of weighing, right, between this idea of legal precision, of getting guilty people in jail and innocent out of jail versus their idea of social stigma, which is what their case rests on. Why should you care about our impacts more than theirs? Well, the first weighing mechanism we give you is the state is inflicting violence on people and has a responsibility to not use violence improperly. The state is not directly responsible for how people respond to its sentences. It is directly responsible for the sentences it levies. Secondly, the harms of failures of justice are massive. Letting murderers walk the streets and reoffend is a disaster. Putting people in jail for 20 or 25 years for something they didn't do is a disaster. No social or reputational harm can outweigh carceral violence. And then thirdly, we think that to some extent, people have a civic duty to prioritize legal precision. People value laws, they value their right to a trial, and that means if they have to experience a trial or be accused themselves, that's a price they have to pay for these rights that we value highly. And so we think you should always lay legal precision over social stigma in this round. For those reasons, proud to propose.
Thank you for that speech. We now welcome the third speaker of the opposition.
Hi, could you give me 20 seconds to get some water if possible? Thank you. Hi. Hi, he and pronouns appears in chat, please. I want to talk about two big things in this speech. First, which side can retry trials better? Second, on fairer decisions within criminal justice systems. First, on retrials. Even though Prop 3 seems to claim that there is no big benefit of proving symmetry on our side, there is. Because I would note one of the biggest pieces of comparative argumentation government was able to give us was they have fairer trials and fairer decisions because they can retry in the future when things like DNA evidence come out. The problem is this was unresponsive to the incentive analysis we gave you in first and second as to why even if not proven doesn't exist, states will still do things like attempt to retry in the instances where new evidence come out. This is due to three reasons. First, states have incentives to reduce the amount of recidivism that goes on in society and reduce the probability that crime occurs in the future. The very analysis they gave us, that a lot of people are risk averse and are scared of violence by criminals, are reasons as to why the state wants to do this if they think someone is guilty. Second, the DA and prosecutors want to look good due to things like electoral incentives, because you want to be the next DA that's elected in. Prop 1 concedes this. I would note that allowing people who the public and jurors think are guilty to go free probably reflects bad on their record. So they still want to do things like reopen cases in the future in order to prosecute. Third, there is backlash and legal liability on the state in instances where they don't do things like cater to individuals who are wrongfully imprisoned due to issues such as the lack of evidence. Now, all I hear proposition say to this is, no, police do things like throw away evidence when cases are closed, and this doesn't happen. Panna, in a vast majority of countries around the world, not proven isn't an option in criminal trials. But in those countries, you still see things like states reopening cases when there is new evidence brought to light, when lawyers and prosecutions bring cases on the docket in order to do so. I would note that them pointing to reality hurts them more, because in reality, states actually do this and Canada cannot lie and get away with it. I want to note then that one of their biggest benefits, which was we can open trials better in the future, is co-opted on our side. The sliver of response we hear in WIP then was, no, there are some margins. Like if the prosecution has a bad case or bad strategy, they can always do things like reopen. But I would note that even in those instances, they require the same preconditions we do to reopen cases, such as having new evidence come to light. So I don't think they can be vague and ambiguous about what these margins are and get away with it in the debate. The second thing I want to talk about then are fairer decisions. What this debate is crying for is a better characterization about the types of juries we are talking about, given that both sides haven't come to a consensus on it. Let's dissect the types of juries that proposition wanted to talk about. First, juries that are extremely risk averse. You don't want to set criminals out in the community because they may harm your family. I would note that if these are the juries that proposition characterizes as a majority, in these juries, you are still not going to get the not proven result. Because to these individuals, if they vote not proven, it means the person who they deem to be guilty will still be out there in society and has the ability to reoffend. So for these types of juries, they are probably going to default to the binary of guilty or not guilty. But second, juries that make the decisions on the basis of convenience. Like, I don't care if this man goes to jail for 70 years. I want to get on Instagram. I just want to note that these scenarios are highly unlikely. One, due to the moral conscience people have. You know that at the end of the day, if you imprison someone, it's their entire livelihood. It's their family that's going to go to waste. Why people who are morally empathetic and just have certain subconscious biases, like Vincent says, are going to resort to this just to go through their social media is unclear to me. Second, even as a juror or a judge, which they completely ignore, by the way, you still want to avoid things like massive backlash and criticism. Like, judges don't want to have the impression that they keep on giving incorrect decisions within court for the sake of things such as convenience, given that it affects things such as promotions. Jurors don't want massive backlash from the public in the aftermath of cases. So then what are the majority of jurors and judges and juries we're talking about in this debate? These are probably people who care about fair criminal justice outcomes. However, there are subconscious biases that are pre-ingrained into these individuals. So for example, you may not be racist, but the fact that the media keeps reporting that black people are more violent than white people makes you develop those subconscious biases on both sides of the house. So these are likely to be the majority of juries we are talking about. Let's then dissect this debate to the two outcomes that could occur. First, people who are actually innocent on either side of the house. I would note that there are structural reasons as to why, if there is insufficient evidence to hold someone guilty, they won't be held guilty. This is due to three reasons. First, states and the incentive to hold things such as these standards of evidence. Because if people who don't meet that requirement are going to keep on getting imprisoned, that is massively harmful for the state, the way it looks on individuals. Given that opposition themselves characterize that states want to maintain the criminal justice system in order for electoral incentives. Second, jury consensus. Even if there are a few members of the jury who think it's within their discretion to imprison these individuals even when there is insufficient evidence, jury consensus, where not even one individual can vote guilty, is something that enables individuals to come to a correct decision. Finally, there are checks and balances on juries. Like the most racist individuals are probably not going to be within juries, given that lawyers can go through a selection process before a trial. I would note then that because people have a basic moral conscience, if they are unable to come to terms with whether or not individuals are guilty and there is insufficient evidence, they would rule innocent. However, these subconscious biases that exist that we characterize to you from first or second enable these individuals to come to another decision, which is not proven, and proposition themselves hinges their case on this being a majority of scenarios. Very quickly, I want to weigh why this is the majority of scenarios, because the probability that these biases exist in society is something proposition concedes to, but the probability that the smallest technicality goes wrong, like police mislabeling evidence, is highly unlikely, given the checks and balances we have on the police system, given that these people don't want to make those mistakes in order to avoid being fired. The only response they have here is, but even if you're proven innocent on your side of the house, people are going to still think you're guilty. So it's a very marginal harm. If you are given the decision not proven, you are damned, because that is a confirmation of guilt without you going to prison. It is basically you telling society that these people indeed are guilty. We just didn't have enough evidence to subject them to the prison system. So I would note that the decision is far more definitive on proposition, and given that the majority of people who are innocent get this decision, it's harmful. Because when you are completely exonerated, you can still have things like ties with your family who are less likely to doubt you because they have close bonds with you. Importantly, you still have a better chance of hiring because companies can justify it on the basis of your merit, given that you have been proven innocent. On the inverse, and where I want to finish weighing this clash, let's assume juries are as perverse as proposition makes them out to be. That is a reason as to why, when people are actually guilty, juries will default to the decision of not proven, because you don't want to see the white man going to jail if you can give him a decision that confirms moral ambiguity but doesn't restrict his freedoms. For all these reasons, oppose.
Thank you for that speech. We now welcome the opposition reply speaker.
Hi, can I be seen and heard clearly? Great. So at the top of this reply, I want to make it clear that retrials are likely on both sides of the house. In the instance where an individual there's been a lack of evidence and new evidence comes up, or the instance where there was a problem in procedure, because those are already grounds for a mistrial in status quo and a retrial in status quo. The differentiating factor between the two sides in this debate is that proposition needs to support a world where, even when there has been no lack of new evidence, or there has been no problem in procedure, there is still an ability for an individual to be considered not proven and put back in double jeopardy. That is what they need to support. That is the burden they failed to prove is moral on their sides of the house. I want to quickly go through a few things at the top of this speech that have been not dealt with that win us this debate. Firstly, that in the instances where people are genuinely guilty, there will more often than not be conclusive evidence because of the fact that they actually did it. This is not an absolute claim. And we recognize that there are some instances where even if a person did it, evidence is not there. But in the vast majority of instances, evidence is present. But even if it is not, we told you that it is the state's duty to ensure that evidence comes about, and you are not allowed to instrumentalize the person who is accused in the search of that, because that's just plain abusive. They say that if the state is forced to give known criminals an innocent verdict, then they can't reopen trials. But surely, if the only reason that they would get off was because of a procedural error, there's already legal backing for them to do things like continue that trial. All of their case rests on this really weird characterization in which the state is simultaneously sufficient and effective, but also ineffective. This does not work. I want to bring up then why a not proven verdict is bad. Firstly, there is a higher guarantee that people assume your guilt for the same reason the jury thought you were guilty. Think about what this means for you when you're trying to seek employment for your community. They want to say this is better because it separates people who are actually not guilty from those that are not proven. But this is not true. If bias exists, what is likely to happen and what we prove will happen is that the individuals that are most likely to have bias, i.e. racial minorities, are the ones that are likely to be given not proven, whereas it is whites that are likely to be given not guilty. They just make it so that you worsen that ambiguity and thus put a stamp on a person who definitively say that they are the ones that committed this crime. The only reason they didn't get out was simply because there wasn't enough evidence. For this reason, I think it's very clear what harm exists on their side. I'll quickly then go over the clashes, and Humaid's already done the internal weighing. I'm going to do the external weighing. Firstly, in terms of which side gets better retrials, the biggest piece of government argumentation doesn't stand in this debate because those are all mechanisms and reasons as to why a mistrial is possible on either side of the world. They have not proven their burden as to the reasons or the instances where where the procedural errors or evidence errors do not exist that they have to support. Second, justice outcomes. Humaid already told you about the types of juries. The juries that are risk averse are not going to give a not proven verdict because they're risk averse. They're going to give you a guilty verdict. Or these are the same people that are going to pull you up from not guilty to not proven because of the very fact that they are risk averse. Second, this idea of juries being just doing things on the basis of convenience is highly unlikely for all the checking mechanisms we have given. So the majority is those that care about fair outcomes but have some conscious biases. These are all the reasons we gave you in first as to why these subconscious biases exist on proposition but do not exist on opposition. It is because it is only on their side of the house where you give them the leeway of ambiguity, where if there is not enough evidence, you as the juror are able to say, the state has given me the ability to go ahead and consider this person not proven because I believe them to be guilty. There is just not enough evidence. This is when you allow jurors the discretion to go ahead and use their racial biases. Our side allows for much fairer outcomes because the incentives of states to maintain the standards of evidence remain, jury consensus remains, checks and balance remain when you have no ambiguity. Thus, the probability of bias is ultra high on their side of the house, damning those that are the most vulnerable, plunging them into continuing to have to do things like plea deals and ruining their lives for the rest of time. This is unjust. Even if you get a slightly more effective justice system, this doesn't justify the immense harm to all those that are innocent. For these reasons, oppose.
Thank you for that speech. And to close the debate, we welcome the proposition reply speaker.
All right, just checking that I'm audible. If you were looking at your timer, the opposition collectively in this debate spent roughly 13.5 minutes on the stance quibble, on the model quibble, on whether or not retrials and appeals are a meaningful counterfactual. This was criminally unstrategic. The parts of our case that hit the hardest against the opposition case operated independent of this counterfactual. Our impacts existed regardless of the model issue. On a basic and principle level, we told you that justice is difficult and non-binary. We ought and we must give options outside of the binary. More importantly, on weighing, we told you that ambiguity leads to bias and tainted decision-making, something that independently operates out of retrials. Peoples on their side of the house are forced into guilty verdicts in cases of ambiguity. People of color on their side are punished unjustly. They're forced into cages and they're sequestered and separated from their families. Third opposition, starting from minute 4 of their speech, finally gives us some responses. What did he say? He says, first, people are empathetic. This does not address the response. Empathy ends where racism starts. Racist and bigoted individuals want to believe that these people are guilty. They have predisposed conceptions that individuals and Black men are violent. Second, they say, there will be backlash against the jury. Jurors are anonymous in the vast majority of cases, so the social backlash does not work. So what this meant then, at the end of the day, there's a swath of people on our side of the house who are not affected by their model quibble or counterfactual, that are locked in cages because there's no third way. Imprecise justice is permanent injustice. Let's talk about other reasons why we win. First, let's talk about legal precision. Even if our case is hinged on the stance quibble, why do we win? First of all, the opposition in stance attempts to close our margin by claiming that mistrials and appeals exist. This failed. There's still a chasm of legal imprecision that exists in the opposition's world that we close. In stance, POI, second, third, down the bench, we told you that alternative mechanisms do not work. Appeals require defendants to have legal resources. Poor people do not have legal resources. Because of a scarcity of resources and court mandates, police will stop looking for evidence, and new evidence is unlikely to come to light in the world of opposition. Second speaker, at minute 6:11, concedes that the bar for trials is high to rebuild their first argument when it was convenient. This was very damaging for opposition. In stance, they concede that there are many cases where a case should be retried for legal precision. But moreover, this humongously large margin of ambiguity is where some of our case operates and comes out at top two. In opposition's world, legal ambiguity allows for a white sexual assaulter to walk free when witnesses don't show and shoves a 17-year-old Black teenager in jail when a jury resorts to racial biases in a moment of tension and pressure. We correct for this when a not proven ballot leads to more evidence, leads to more retrospective technology emerging, and leads to witnesses going on stage. The opposition impact here and the opposition response is that jurors are a good check and balances. The reply already contradicted this. They said that jurors are racist in response to our argument. What this means then is that the part of our case that operates independently of our model wins, and the part of our case that is hinged on the stance quibble wins as well, because there's still a significant margin in which our case operates. Let's talk about stigma then. In opposition, a not guilty verdict is a guilty verdict in the court of public opinion. For various reasons we gave down the bench, an innocent verdict does not meaningfully exonerate a person. This engaged with the most charitable version of the opposition's case. They claim that a not proven verdict breeds stigma, and they asserted this down the bench. But we told you that a not guilty verdict does the same. Look at how ex-cons, for instance, as we pointed out in Anushka's speech, severely struggle in getting a job because there's no meaningful tipping point on their side of the house. In their world, any perception of going through a trial taints someone's perception because individuals are risk adverse, and there's incentives for the media to sensationalize these individuals as criminals. But in our world, we exonerate people who are innocent. On weighing, we think this is massively important. Marginal changes in stigma pale in comparison to innocent people being locked up in their world. But moreover, these are actually innocent people that we exonerate, that we improve stigma, that can have relationships with their girlfriend and their neighbor, that can actually have a job on their side of the house. There's a swath of material in our side of the house that is not engaged with, that operates independent of the model. But even if the vast majority of our material is hinged on the model, we prove that there's a significant margin in which we win. Imprecise justice is permanent injustice. We're very happy to propose.
Thank you so much for that speech. Thank you, everyone, for what was an excellent debate. I am not sure. Well, first of all, can the stream end, I guess? And second of all, can the judges please